his whole life is devoted to, words of Eric Butler's, the continuity of intention. And the continuity of intention of the Australian League of Rights is to promote and do their best to see that those 10 policies of the League are fulfilled. And of course the first one is the Christian revelation of God. And for me, and the things that my son has spoken of, and speaking with David Mitchell here tonight, where he was telling me about the joy that he and his wife have in seeing a young girl that has come under their care to develop and to flower, to really flower as a human being should do. That to me is the whole purpose of the Australian League of Rights. That the economic system, the financial system, the education system is there to serve and see that each and every one of us, as we develop and grow, do flower to the intent that God would have us. And those systems are there to see that that happens. So if you ask me, what do I see as the purpose of the Australian League of Rights, and of course the response to my son's toast to the League, it is that. And of course I see it even with him in what he is doing. And you don't do it by dominating or trying to rule. You do it by serving one another. So I want to say thank you, Arnie, and thank you to all the folk who are here tonight for coming to enjoy with us first of all the memorial dinner of one of the greatest persons that I have known, Frank Borden. And Frank served his nation to me and through the League of Rights for as long as I knew him. And he demonstrated to me those principles that I seek to uphold through the League. Before I finish, though, I just want to tell a story. It was a marvellous story, and it concerns David Mitchell, but to me it shows how a brilliant man like that knows how to deal with people. And it was called a Daniel 244 conference in Canberra one year. And if you'll notice, I wear slacks. And what it was, the subject was about whether a woman should wear pants or a dress. And of course there was such a discussion amongst them. There was a Christian. And of course there were a number of men who thought that women should wear dresses. You see, well, of course, me being the gentle, placid character that you all know that I am, of course, my ire was raised, and so I had to have my say. And but one thing that I knew he was playing his audience along, because of course it was whether it was scripturally based. Well, anyone who knows the Middle East knows that if you look, you see women wear pants, don't they? And so anyhow, it was that evening when we all came down to dinner, and we're all seated we're all standing in the dining room waiting to be seated. And guess who made his grand entrance? And bear in mind that most thought that women should wear dresses, not pants. And guess who made his grand entrance in a kilt?
I love
it. Now I will finish.
Perfect.
It is people such as Frank Borden and Eric Butler and the writings of men, Serge Douglas, and men such as David Mitchell, who have influenced my life and my thinking. And I guess they'll continue to do so. So thank you, ladies and gentlemen. Enjoy the meal, enjoy the fellowship, and let's do our best that we all develop to our greatest extent. Thank you.
Luke's originally approached him to come to South Australia for this weekend. She was concerned that with the strain of travel and the conduct of the seminar that he might not feel like taking an extremely active part in the dinner, and was more than pleasantly surprised to find that he intended to continue the work of the afternoon on into the dinner atmosphere, and hence the flyer inside the menu and pro forma for tonight's proceedings. So may I again welcome Dr. David Mitchell to you to continue to expand upon this afternoon.
Again, what a privilege and a pleasure it is for me to be with you, and a special privilege to be invited to be the speaker at the Frank Borden Memorial Dinner. I remember Frank with great affection and friendship and admiration of his wonderful work over many years. And here I've been given this special privilege for which I say thank you. I indicated that tonight I would speak about the Governor-General, for it is Governor-General is a topic on many lips at present. Some saying that the Governor-General is invalidly appointed, some people saying other things about the Governor-General and his powers, and I want to look at those things tonight if you will bear with me. Now, during the afternoon, one of the things I omitted to say, and it was important for this afternoon's session, for I don't know where we get back to it, and I must, before getting to the Governor-General, say that there is a myth running around the country that common law overrides statute law. That, my friends, is a total myth. The reverse is true, as I hinted at in our first session this morning. The common law is the law that comes through the law courts, the law that just exists, that comes through the law courts. Misunderstood, misrepresented it may be by the law courts. The legislature has the responsibility to correct it all, to override the common law for proper purposes. Now, what has happened is that the legislature, with its legislation, is forgetting about the historic concept that law exists, and is making all sorts of new laws based on humanist, political party thinking. And although the legislature might be misusing the historic powers of the legislature and the historic responsibility of the legislature, the fact is that common law can be changed by statute, and is changed by statute. And even the Magna Carta is changed by statute. And the Bill of Rights of 1688, 1689 is changed by statute. So, please understand that the common law is subject to what the Parliament determines. There is a concept afoot in the United Kingdom called the sovereignty of Parliament. This was, I suppose, a myth introduced into the law by a lawyer named Dicey, who has become very popular over the years, but to my mind he is aptly named. Be that as it may, in Australia, in the federal sphere, the Parliament is not supreme, the Constitution is. This is different from the situation in the United Kingdom, where the Parliament nowadays acts as if it is supreme, and indeed that is the fact of the situation. But the Constitution in Australia, the agreement among the states whereby they would operate together, is the supreme law in Australia, interpreted by the High Court. Now, in the Constitution, the executive power in Australia is vested in the Governor-General. If you look at section 61 of the Constitution, you will see the executive power of the Commonwealth is vested in the Queen and is exercisable by the Governor-General as the Queen's representative, and extends to the execution and maintenance of this Constitution and the laws of the Commonwealth. Yes, the executive power is vested in the Queen, but is exercisable only by the Governor-General as the Queen's representative. The term Queen's representative has caused a lot of confusion. What does it mean? It does not mean that the Governor-General does what the Queen tells him. Quite on the contrary. The Governor-General takes no directions from the Queen and never has. There has been a lot of talk recently about the invalidity of letters patent. You notice I say letters patent rather than letters patent. Letters patent issued by the Queen in relation to the Governor-General. Certainly, the letters patent issued early in the time of the Commonwealth of Australia were completely invalid because they attempted to give some direction to the Governor-General. And the Queen, under the Constitution, has no power or authority to direct the Governor-General. The Governor-General does not consult the Queen. The Governor-General does not report to the Queen. The Governor-General is the one who has the executive power in Australia. Not the legislative power, that rests in the Parliament. Not the judicial power, that rests in the courts. Those who were here earlier in the day will remember that I was talking about the system of checks and balances, whereby the court makes a decision, it appears to be a wrong decision, the Parliament legislates to make it a right decision, that is the legislature supplanting or overriding the common law, the executive, the King, or in our case the Governor-General, giving assent to the legislation of the Parliament, the court determining whether that legislation, even assented to by the Governor-General, is constitutional or not. So we have our system of checks and balances very well entrenched in the Australian legal system. There is, of course, a body known as the Executive Council. The Executive Council is basically the Governor-General and the Cabinet. And the Cabinet should not make any decisions or directions without the assent of the Governor-General in the Executive Council. An Executive Council decision chaired by the Governor-General. Parliament legislates. It has a very wide scope within the terms of the Constitution, of course, limited by the Constitution, a wide scope to legislate as it will. However, every piece of legislation that goes through the Parliament does not become law until the royal assent is given to the legislation. Royal assent has nothing to do with the Queen. The Governor-General is the Queen's representative. But why and how? How does he represent the Queen? He represents the Queen in this way, and in this way almost only. The Queen, as Don Octoloni mentioned in the Loyal Toast, gives undertakings as to how the law is to be administered, how she will maintain the law of God, will ensure that the law relevant to each of the people groups under her sovereignty, how their law will be maintained by her, and the Governor-General represents the Queen in that it is his responsibility to maintain the oaths that the Queen makes when she is enthroned. That is how he represents the Queen. He represents the Queen in maintaining the integrity of the law. Please understand, I hope I've got that through clearly. Now, I might need to repeat several times in the midst of opposition. I understand now how the government feels with the opposition sniping away at them all the time. Not that I'm suggesting that young Brendan is opposition. He's my special friend. And when I finish, I'm going to give him an opportunity to reply to everything I say. Aren't I, Brendan? Braden. Sorry, I've got the name a little bit wrong, but that's me. I get everything a bit confused, you see. When a proposed law passed by both houses of the Parliament is presented to the Governor-General for the Queen's assent, that is, for assent in terms of the Queen's coronation oath, not for the Queen to assent, but it's presented to the Governor-General for the royal assent. He, that is the Governor-General, not the Queen, is presented to the Governor-General for the Queen's assent. He shall declare according to his discretion, and please note this word discretion, he shall declare according to his discretion, but subject to this Constitution, that he assents in the Queen's name, or that he withholds assent, or that he reserves the law for the Queen's pleasure. If the Governor-General reserves the law for the Queen's pleasure, he does not send the law off to England for the Queen to think about and decide whether she's going to assent or not. She has no power, no right to assent to any Australian law. It is the Governor-General who assents. What then can it possibly mean when it says, when the Constitution says that he reserves the law for the Queen's pleasure? What it means is that I can't really decide what I should do about this at the moment. I'm not going to sign it now, I'll have a think about it. And what does he do when he has a think about it? Maybe he consults the Chief Justice of the High Court, as the Governor-General did at the time of the incident commonly referred to as the dismissal. The Governor-General took advice from the Chief Justice of the High Court. Maybe you might even find, sir or madam, that the Governor-General would want to take advice from you. He might perceive that you are the expert in the area, and he might want to talk to you about it. Reserving it for the Queen's pleasure is simply authorising the Governor-General to have a bit of a think, discuss with whom he will, get his own facts and information before he puts his signature to the legislation that has passed through both houses of the Federal Parliament. This word discretion, what does that mean? Does this mean that the Governor-General can exercise a whim as to whether he will assent to a bill, or whether he will withhold assent, or whether he will have a think about it? Or is there some guidance for how he exercises his discretion? there is guidance for how he exercises his discretion. The way in which he exercises his discretion is to consider the basis of the law in this country. It is, of course, he cannot make an absolute decision on what God means in the Scriptures, or indeed he cannot make an absolute decision as to what the people might want. That he has a discretion to deal with an intelligent understanding of the truth of the matter. Just in the way that the barons consulted the church at the time of Magna Carta, so the Governor-General might consult with the church as to how the law should be interpreted, or he might, as I said a moment ago, consult with someone else, than even you. He has to come to a conclusion, an intelligent conclusion, on balance, using all the information in his hands. I have mentioned earlier in the day about the goods and services tax. Should the Governor-General have withheld his assent to the goods and services tax? I believe he should. In fact, I think he had a duty to do so. And I think he was acting contrary to the Constitution. Now, I stand at this platform and say that blatantly and without hesitation. But I know that judges, prime ministers, and politicians of all colours say, David, you've got it completely wrong. There is a tradition, and in politics we call tradition convention. There's a convention, a binding convention, on the Governor-General to do exactly what the Parliament tells him. He has no discretion. He might have once, but nowadays there's a convention that the Governor-General will not exercise his discretion, but will sign anything that the Parliament puts before him. Now, in a moment, did I tell you a moment ago that in Australia there is a supremacy of the Constitution, not a supremacy of Parliament, not a supremacy of the courts, but a supremacy of the Constitution? And they tell me that there is a convention that is supreme over the Constitution. How can that be? To my mind, this section 58 of the Constitution, is one of the keys to what our Constitution is all about. You might reply saying, but David, if the Governor-General is the person who can decide in the ultimate what laws we have, we are not simply in a totalitarian country, we're in a downright dictatorship, an unelected dictatorship. No, my friends, that is not right. Of course, the responsibility that the Governor-General has is to act conscientiously in relation to the decision of the parliamentarians who have been elected by the vote of the people, and conscientiously in relation to the will of the people, and conscientiously in relation to the law of God. These are the responsibilities of the Governor-General. Yes, it is true that he has remarkable power in being able to disallow laws. In the ordinary course of events, he does not have the power to make laws. We sometimes hear about something called the reserved powers. And the reserved powers include, it seems, the power to dismiss a government or a prime minister. To dismiss at discretion. There are other reserved powers too. Supposing, for example, government were to completely break down. Early in the Second World War, there was an unfortunate air crash outside Canberra in which a large number of the cabinet ministers died in the air crash. There's a memorial there that you can go and visit, and it's quite an interesting visit, and that had a dramatic effect on the government and the change of government in Australia at that time. Supposing a bomb dropped on Parliament House when it was sitting, we had no Parliament at all, no elected representatives, no Prime Minister, no Leader of the Opposition, no Minister for this or that or the other. Who would take control of the country? The Governor-General. The Governor-General, he would have responsibilities to call an election as soon as he could, the same as the responsibility he had at the time that Whitlam was dismissed from the Lodge, a responsibility which the Governor-General fulfilled at that time, and he was able to call the then Leader of the Opposition to form a government. But the Governor-General could conceivably, in an emergency situation, become the director, controller, or even, you might say, dictator, although I would not use that term. It could happen. But that is not the situation that we're in now. And Section 58 of the Constitution does not establish a dictatorship. And I hope I'm making that reasonably clear, if not fully complete. Now, the Queen may disallow any law within 1 year from the Governor-General's assent. Well, David, didn't you say the Queen has no power? Yes, exactly what I said. The Queen has no power. So, what Section 59 means is the Governor-General finds he's made a terrible mistake in assenting to a law, and the disaster is resulting from it. He can, within 1 year, repeal the law, send it back to the Parliament and say, hey, look at this again. This isn't the law anymore. You'll have to start all over again. This, to my mind, could be a very important function of the Governor-General. I know the term Queen is used, but when we understand that the Governor-General is the person who has the actual executive function on behalf of the Queen's responsibilities, we get the picture of what is really meant in these passages. I was asked earlier on whether the Prime Minister or the Minister for Defence and the Armed Forces, or even the Cabinet, had power to send troops to Iraq. I've sort of dodged those questions a little bit. Listen to this. The Command-in-Chief of the Naval and Military Forces of the Commonwealth is vested in the Governor-General as the Queen's representative. Section 68. It is the Governor-General who is Commander-in-Chief. Oh no, I've been officially told, oh no, that's purely ceremonial. It doesn't mean he's Commander-in-Chief. It means he's ceremonial Commander-in-Chief. My friends, why doesn't it say so? Placing the Governor-General as Commander-in-Chief with power to command the military forces, to order them to go here, to do this, to do that, to go and fight in Iraq, seems to be an enormous and unreasonable power in Australia. It is a power for the protection of the people. The Governor-General can command the armed forces, that is true, but who is responsible for arranging for the payment and equipment of the armed forces? It is the Parliament. It is the Parliament. And this is intended as a protection for the people, so that the armed forces cannot be used against the people of the country or used in any way without the consent of the Commander-in-Chief. But on the other hand, the Governor-General, the Commander-in-Chief, can't send them off to do something which the Parliament doesn't approve because they need to be paid and equipped. So this is part of the checks and balances system that we have in Australia, and it's so very important It is the Governor General who should have sent the troops to Iraq. I do not think he did. I think the Prime Minister did. And the Prime Minister has been usurping the Governor General more and more and more over recent years. Until Whitlam became Prime Minister of Australia in, when was it, 1971, 72. In the early 1970s, the Prime Minister always said, Her Majesty's government will do this or will do that. Whitlam, Prime Minister Whitlam, my government will do this, my government will do that. And that Whitlam practice has been continued on ever since, even with our present Prime Minister. My government. It is not his government. It is Her Majesty's government. What's it got to do with the Queen when I say it's Her Majesty's government? Look, it's the Queen's responsibilities. The Queen, what's the grammatical term? Synecdoche, is it? When the term Queen is used for the Queen's authority. And her authority is limited by her coronation oaths. The oaths that have existed from the 10th century, from the coronation of King Edgar, right up to the present time. And so it should be Her Majesty's government, a government limited in those very ways. The office of Governor General is a very interesting one. In today's Australia, one would need a very well-trained, very brave man to be Governor General of this country. Someone who is prepared to say, look, here's the Constitution, Mr. Prime Minister. Here's the Constitution. I'm not going to sign a bill for the goods and services tax because I don't believe the people have voted for it. And I'm not suggesting that I would either be sufficiently brave or sufficiently competent to be Governor General, but if I had those qualities and happened to be Governor General, I would also have said, and what is more, Mr. Prime Minister, I do not find any authority in the Scriptures for a goods and services tax. You're going to have to convince me that I can find that taxation is authorised, but I can't find an end-user tax authorised. Before I give assent to this, you'll have to convince me. I'm open to conviction. You can get Cardinal Pell or Archbishop Jensen or your local rector on the job if you like, but I need to be convinced of what the Constitution, that is, the Constitution behind the Constitution, has to say about this matter. I'm the one who's got to be convinced. It is my discretion. Yes, it has been passed through Parliament, and that is a very big influence on me. But I'm not satisfied that you gave any thought to the Scriptures when you legislated for this tax. Now, please, I repeat, I'm not suggesting that I would be brave enough to do that, nor am I suggesting that I am properly equipped and trained to do that. Does this mean that I am saying that the Governor General has to be a practising and astute Christian in order to be appointed as Governor General? No, that's not what I'm saying at all. In 1925, Sir Isaac Isaacs was appointed as Governor General of this country, and Sir Isaac Isaacs... I'm sorry? Sir Isaac Isaacs, shortly after his appointment, had the privilege of addressing a special festival of what was then the British and Foreign Bible Society. In that address, he said, I am in a most strange position. You know that I'm a practicing Orthodox Jew. But I recognize that the basic law in Australia, the undergirding of the law in Australia, is the Christian understanding of the Ten Commandments, understood in the light of the whole of the Scripture, of the Christian Scriptures. I understand that. I therefore have a duty, to the best of my ability, to understand the Christian principles of right and wrong, the Christian principles of law, in order to fulfill my responsibility as Governor General. And I undertake to do my very best to fulfill my responsibilities in this and in every regard. Of course, Sir Isaac Isaacs was absolutely right. And it's a pity that that has been forgotten. It is often said that Archbishop Hollingworth was a terrible appointment as Governor General because you've got to keep church and state separate. You can't let church and state get mixed up together, can you? All right, I am prepared to recognise that the church has a different responsibility from the responsibility of the civil government. Not only am I prepared to do so, it is demonstrably so from the Scriptures. However, if we take the Christian Scriptures, we perceive that both the civil government and the church have their respective responsibilities under God. Because their responsibilities are under God, the government may, from time to time, need advice from the church. You know that I'm a Presbyterian. Several years ago I would have said I was a one-eyed, bigoted Presbyterian. I now say I'm just a Presbyterian. We understand the Westminster Confession to be the way, to be an exposition of the Scripture and the way in which ministers and elders of the Presbyterian Church understand the Scriptures. And I'm required on my ordination to undertake that the way I understand the Scriptures is explained in the Westminster Confession of Faith. One provision of the Westminster Confession of Faith that causes a lot of trouble is that it provides that the government of the country may call an assembly of the church. And they say, this is terrible. This is placing the church under government control. I say, no, that is not what it's about at all. It's saying we recognise that the government may ask the church for advice. Not thinking necessarily that in today's world they ever will, but that's what it's there for, my friends, to recognise that the government has a duty under God and that the church has a duty to guide the government under God. If the government is going to fulfill its duty, and if the church is going to fulfill its duty, both must be orientated toward the same end. I suppose it's a little bit of a sidetrack to say I was very privileged some years ago to speak at a ministers' conference. Usually only the very top people are invited to speak at that conference. The conference only happens once in X number of years, and I found myself with an invitation, and I couldn't resist, being me and wanting to blow my mouth off. I couldn't resist the opportunity to speak there at this very high-flying conference. The speaker before me said that above all things, a preacher must realise that he must never preach politics from his pulpit. You must keep church and state completely separate. Politics are nothing to do with the pulpit, and every preacher throughout the world should remember that. Of course, being me, I abused my speaker's privilege, and instead of restricting myself to what I was supposed to be talking about, I said that I was very impressed and encouraged with the excellent address from my brother, John so-and-so. I'm afraid I totally disagree with him. That I must preach politics from my pulpit. What is politics? Politics relates to the way society is organised, the principles in society. And when I go into my pulpit on Sunday morning and say, the text for today is, thou shalt not steal, I am making a direct political statement. The law should require that thou shalt not steal. And I apologise to John, but my responsibility is of course spiritual, but it is also political, because I must address the issues of society. And similarly, the government's responsibility is political, but also spiritual, because the government is appointed as a government under God. I was asked during the day about Romans chapter 12, Romans chapter 13, where we find some instructions. Obey every direction of the government, it says. I replied to the question that was put to me, saying I will probably preach on that tomorrow morning. I don't think I will, because I preached on that once before at League of Rights. And there are a number of people present who might conceivably remember that sermon. If you look at that chapter, if you look at it carefully, you will see that it says that the government is the minister of God. That is, the government is supposed to be serving God. That the government is responsible to God. And that the government is supposed to maintain the measure of right and wrong in society. The measure of God's truth in society. And this is what that chapter is all about. And that's what we've been talking about today. And that's what the Governor-General's responsibility is. If we have a head of state in Australia, it is the Governor-General. I've been through that earlier in the day, and even for the sake of those who are here and were not here earlier in the day, I will not traverse that ground again at this time. As I move on to the next point, and I see my time is running out very quickly. Sorry about talking so much, but when you I might say that historically a Presbyterian minister was expected to preach, or if he was just invited to speak for a minimum of 3 hours. And you will understand how I feel somewhat limited. I was thinking of the employment interview the other day, where the employer had 2 applicants for 2 positions, 2 similar or identical positions. And there were the 2 applicants, and the 2 applicants were good, firm friends. One of them was pretty bright, and the other was pretty dense. So the employer said, well, I'm just going to ask you 2 questions just to check on your ability to understand. If I got a stick and poked one of your eyes out, what would you be? Oh, said the brown fellow, I'd be half blind. And then he said, and if I got my stick and poked the other eye out, what would you be? He said, I'd be totally blind. So, well, those are the questions I always ask, so you've done very well. And as he went out, he said to his friend, the 2 questions are, if your right eye, if one of your eyes is poked out, what will you be? And the answer is half blind. And the next question is, if your other eye is poked out, what will you be? Totally blind. So, the dumb applicant goes into the interview, and the prospective employer says to him, if I cut one of your ears off, what will you be? Half blind. If I cut your other ear off, what will you be? Totally blind. Now listen, just explain to me what your ears have got to do with your sight. Well, Mr. Prospective Employer, if you cut my ears off, I'd have nothing to hang my glasses on. I find myself something in a situation of a rather dumb candidate for the position. Now, as far as the Queen is concerned, as far as the King is concerned, as Don Octoloni said earlier, the position is usually, but not always, hereditary. And one of the great advantages of this is that the heir apparent, can be trained from infancy for the job that he's going to be doing in adult life. He can really be an expert in the responsibility of the sovereign. The Governor-General does not have that privilege. The Governor-General doesn't know he's going to be Governor-General until he's actually approached and appointed. So he needs, I think, a crash course in Governor-General's responsibilities and duties. And he needs to have these sections of the Constitution that I've just been pointing to carefully explained to him. And before the appointment is finalised, he really needs to understand exactly his powers and his responsibilities. I'm not sure that any of our recent Governors-General have had that privilege. The last one that I'm aware of that was really intent on determining these responsibilities was the 1925 Governor-General, who I've already mentioned, Sir Isaac Isaac. Now, there may have been others. I do not know. I would believe that Sir Zelman Cowen, one of Australia's leading constitutional figures of all time, would know all this. And I have little doubt that he would agree with all I'm saying tonight. I don't know, when he was Governor-General, I don't know whether he put any of it into practice. I would have thought that Hollingworth, or somebody in his position, would have had a good head start on these things. I'm not suggesting that Hollingworth was ever a good choice, but then you see I'm biased and bigoted. For I've known Hollingworth, we've known each other for a lot of years, and I can't say that we've related all that well. Our last meeting, face-to-face personal meeting, was at the Constitutional Convention, where I was privileged to be an elected delegate. I was privileged to speak on the first day of the Constitutional Convention, and I said some of the kinds of things I've been saying today. I compressed them, and I think I presented them more fluently and so on. One shouldn't be pleased with himself, but I was pleased with that first day performance. Now, in general terms, from my point of view, he's the sort of person who might be selected, as is the present Governor-General. But I think the present Governor-General knows nothing about his task at all. He was a very good soldier. He's had no experience in the law, or in dealing with the Constitution, or in dealing with politicians, or in confronting the whole of the Federal Parliament. or in realising what power he has in relation to being Commander-in-Chief of the Armed Forces. Now, look, I'd love to go on talking for ages, but you'll never have me again if I do.